My name's Sarah Veal. I am the Chair of Protect's Advisory Council, which is a body that comprises wise experts, my note here says, and whistleblower ambassadors, which sounds like a fantastic phrase to me. And we meet twice a year to offer our perspective on the policy and the direction of Protect. I'm really delighted to see so many fellow council members out here, and you're going to meet a couple more of them during the afternoon. I've been involved in the charity for many, many years, particularly in my capacity as was Head of Equality and Employment Rights at the Trades Union Congress. Right from the outset, from when I was earlier days at the TUC, when I was a more junior person, because the TUC is rather hierarchical, I was the Senior Employment Rights Officer, and I held that position when there was a Labour government elected in 1997. Seems a long time ago now. And one of the things that was bridging, really, the government before, which was a Conservative government, most of you are probably too young to remember all this, and then there was a Labour government, and during this period there was a private members' bill, the Public Interest Disclosure Bill, that had been put together by Maurice Frankel, Guy Den and Richard Shepherd, who was a backbench Conservative MP. And I have to say that the TUC's gut instincts were not to touch anything Conservative, really, if possible, especially with the Labour government coming in, who we felt rather closer to. But we saw the wisdom of this piece of legislation. And when Labour was elected, we had a meeting with the lovely Ian McCartney, who is still alive and kicking, who was the Employment Relations Minister at the time, and he was very keen to make sure that this bill had a swift, unimpeded passage. And we went to a meeting with Ian McCartney. We got on very well with him, and we said that we think this bill is a very good idea, and we're very happy to, basically stand out of the way or give it our support, whichever was the most helpful to him at the time. And you can imagine TUC sometimes is more helpful being quiet than it was being noisy. But we said there is one thing we'd like to see in this bill, and I'm saying this to you today because to me personally, and I think still to the TUC, there is one category of person to whom a whistleblower can make a protected disclosure, and that's an accredited trade union officer. And we tried for that, and we kept on trying for that, and I think with Protect, we still want to see that. We can't understand why that can't be a category to whom it's protected to raise your concern. And that's, after all, what trade unions do. They're used to taking on confidential information and handling it in the best possible way. And, of course, they're good at working with the workforce and with the employer. So really, that's the end of my little pitch for that. But I do think it's something that we still need to think about. I suppose the only other thing, just very quickly, is it reminded me of the meeting with Ian McCartney where we discussed this. He was very, very hard-working, and I think had been suffering some minor heart problems. And he was on some kind of, what do you call them, beta blockers, whatever it was, some kind of medication to just keep him calm and make sure he didn't damage his heart. And the person who was with our delegation, I'll call him Dave, because every male trade union officer of that generation was called Dave or Mick. So I think I'm quite safe in just saying Dave. Anyway, Dave was a bruiser. And Dave was always angry. And Dave went into the meeting and he started banging his fists on the table and saying, "We've got to have trade union in this. Got to have it. Got to have it. What do you think of that?" And Ian looked at him like that and said, "What I think is that you should take one of these." And he gave his bottle of beta blockers to Dave. Dave went, "No." Like that. Honestly, he ate about 6 of them. So half that meeting, I was concentrating, I really was, on the bill and all the rest of it. But at the back of my mind, I was thinking, Dave is going to collapse. He is absolutely bound to collapse. Did he collapse? No. He kept going at full throttle for the whole rest of the day. So my conclusion was that either Ian was on placebos or that trade union officers of that generation were made of very strong stuff. But anyway, that's a little bit of a digression, just an after-lunch entertainment for you. We are now going to move to what I'm told is a short video address from the Minister currently in charge of whistleblowing at the Department of Business and Trade. You'll probably know his name is Kevin Hollinrake, and his job description is Enterprise, Markets and Small Business. So I think if the technology works, we're going to hear from Kevin Hollinrake.
first of all, happy anniversary, and I'm sorry I can't be there at the conference in person. Much of my work got involved in the business banking areas of our economy, and some of the things that went wrong and how businesses were mistreated led me into all kinds of different areas of economic crime. I think every single instance I saw in terms of some of the scandals that came to light as a result of whistleblowers. So that's how important this conversation is. We need to get the framework right for whistleblowers, and I'm delighted I'm the minister responsible. And you said lots of things on the backbench, of course, that you've got to live up to as a minister. So delighted to be taking part in the review that we're undertaking right now, and keen to make sure the future framework for whistleblowers is absolutely right, because many, many people there are taking difficult decisions to do the right thing and come forward, and so we can really find out what's really going wrong in our economy. We're always conscious of business burdens. There's a natural thought when anything goes wrong that you regulate, you bring in new regulations, but I think it's right we do that cautiously because we don't want to add to business burdens. But nevertheless, I think there is a real justification for this review. I think there are some real questions whether the current scope of the definition, for example, around worker is sufficient to protect people who have done the right thing who have a different employment category, for example. I dealt with cases where people have fallen outside the scope of the current definitions. So clearly that's a fundamental part of what the review should look at in terms of the definitions of workers, for example, to make sure anybody who's done the right thing is properly covered by the legislation. The legislation itself, PEDA, of course, is an employment law-based regulation, and that's the way it was drafted. We've got to make sure that still works and make adjustments where possible. The quickest way to adjust anything, if we decide there is a case for review, is through secondary legislation, of course. So, and there's not that much time left in this Parliament, of course, probably just over a year, I guess. So we want action today. Wherever we can take action today that's pragmatic, that makes a difference to people's lives, that actually helps businesses do the right thing as well. And many businesses want to do the right thing, and any business listening to this should really have a good whistleblowing procedures and policies, because it can help you to run your business more effectively, more efficiently, and root out wrongdoing.
Thinking about the whistleblowing framework review that's currently going on, what will it reveal about access to justice, and do you think there are changes that are needed in that sort of area?
I'm a big fan of the employment tribunal process, and the number one thing I raise, I say that because nobody wants to go to one. Employees don't, employers don't, and that creates a deterrent to making sure people don't do the wrong thing, because you're going to end up in a public forum. There is no overarching employment regulator in the UK. Yes, we have 32 million people employed. One of the reasons why things don't go wrong is the deterrent of an employment tribunal, which is subject to public scrutiny. So I think that does a fantastic job, but clearly that should be a backup option. All the experience I've had of when things have gone wrong in terms of whether this mistreatment has happened or inappropriate behaviour, it could have been dealt with so much easier right at the start, which would have been better for the employer, better for the whistleblower, and ultimately things cost a lot more by not dealing with it right at the start and nipping things in the bud. So that's the way employers and their employees should work in terms of those concerns brought forward, deal with them at the company level and take them seriously, and then it would not need to go to an employment tribunal. But if it does, I think it's absolutely right that is the process we have in place to deliver justice. Of course, we've got to make sure they're easier to access, there's more capacity, and people will say it takes too long, and I understand all that. And regulators definitely have a part to play in that, in making sure they take these concerns when raised more seriously. The key fundamental is, do we want to make sure that whistleblowers are treated properly, they're protected properly, they are compensated where things have gone wrong? Absolutely we do. We need to make sure that is the case. So let's look at the review first, and where we need to legislate, we'll look at that, and nothing is off the table in terms of the action we would take if we decide that action needs to be taken. And thank you for all the work you do. Protect does. It does a fantastic job in helping the individual whistleblowers themselves, but also in terms of bringing the debate to Parliament and to people and policy makers. Hugely important, and so I know you're contributing to the review, which is, obviously engaging with our officials as you do on an ongoing basis. So thank you for all the work you do.
There we are, and we're going to segue very neatly into another short video, this time from the opposition, and it's going to be Justin Madders MP, who's the Shadow Minister for Employment Rights and the Future of Work. So another short clip from the opposition.
Good afternoon, everyone. My name is Justin Manners. I am the Member of Parliament for Ellesmere Port and Neston, but also the Shadow Minister for Business, Employment Rights and Levelling Up. I want to take the opportunity to pay tribute to the important work Protect undertakes, both through providing free advice and support to individuals and in their work campaigning in Westminster. Protect works tirelessly to offer those who choose to blow the whistle the rightful support that they deserve. But it is clear that more needs to be done to support whistleblowers. The news is sadly far too full of incidences where whistleblowers are ignored, or even worse, victimised for speaking up. The Lucy Letby case nearby is a particularly tragic and recent example of that. But we know there are culture problems in all sorts of organisations. Workers do speak up, many do so successfully, but all too many do so at a cost to themselves. They face a detriment at work, or they face victimisation as a result. The bravery that they have shown can often lead to long-term impacts on their career or a heavy toll on their personal mental health. Sadly, as we know all too well, doing the right thing can often come at an enormous personal cost to the whistleblowers. This year marks the 25th anniversary of the passing of the Public Disclosure Act. That, of course, was a significant milestone, being a groundbreaking piece of legislation, I'm very proud to say was introduced by the last Labour government, because it meant for the first time that workers were given legal protection against victimisation, dismissal, or being forced out of their job for raising questions about wrongdoing in their workplace. It was landmark not only in its provision, but also because of the resounding support it received across the House. Indeed, it's the only piece of employment legislation which, to my knowledge, has received such cross-party support. So we know that strong whistleblowing protections are vital for both the individuals speaking out and for society as a whole. Like many employment protections, businesses benefit as well from having people having the confidence to speak up when they see wrongdoing, because it acts as an early warning system. It promotes good governance and it enhances credibility to all those around. Listening to whistleblowers, proactively taking steps to prevent victimisation and addressing the concerns as early as possible can be seen as an investment in the future of the organisation. And I know you'll be hearing from some speakers who understand this later on today. The Labour Party also understands this. We know how important it is for workers to be able to speak up confidently and without fear of reprisal. And our new deal for working people, as I'm sure many of you will already know, does actually commit to strengthening the existing set of rights and protections for whistleblowers, because we understand that whistleblowers play a vital function in our society, and we know that when whistleblowers are protected from being silenced, society as a whole also prospers. So introducing an employment bill based on the New Deal for Working People will be one of Labour's priorities when in government. Indeed, we'll bring forward legislation in the first 100 days, and it is a comprehensive plan to bring the world of work into the 21st century, upgrading rights and regulations. Thank you for listening, and I hope we have the opportunity to implement some of our ideas in government soon.
There we are. OK, so the Minister said, I think, if I heard him right, that he wants to take action that's pragmatic and helps both whistleblowers and businesses to do the right thing. Let's see if the panel that we're about to hear agrees with what those actions might be. I'm delighted to welcome Mukhtiar Singh, employment barrister and a fellow member of Protect's Council, who's going to chair this debate about legal reform. Mukhtiar is going to introduce the panel, and we'll hear some views about what changes to the law we're hoping this government, or the next, will prioritise. Over to you, Mukhtiar.
Thank you, and good afternoon to everyone. We're going to be discussing legal reform of whistleblowing protection, and perhaps respond to some of the comments made by Tom Devine earlier today, that the PIDA is one of the weakest protection legislation frameworks in the world, and also reflect upon the problem of having pioneering legislation turning to dinosaur legislation. Please ask yourselves, how do you feel about wrongdoing and the truth? This can be from your perspective as a private individual, an employee, a regulator, a policymaker, or other professional setting. Perhaps there is ambivalence to wrongdoing, something you have to do in a competitive world, or perhaps it's fine as long as it doesn't affect you. Our relationship with wrongdoing and truth tells us about the type of society we are. Do we expect truth from our leaders? Although we're not at a stage where our next leader may lead from the confines of a prison cell, our understanding and expectations of standards appear to have changed. Following PIDA, Protectors campaigned tirelessly for wider protection. In 2021, it presented a whistleblowing bill as part of its Let's Fix Whistleblowing Law campaign. This was at a time when Protect was being inundated with calls looking to blow the whistle on COVID health and safety related issues and concerns about fraud. Just in the last 5 years, we've had numerous high-profile whistleblowers not only revealing extraordinary levels of wrongdoing, but who have suffered detriment as a result. And I'm grateful to those whistleblowers, some of which who have attended today. For example, Helen Evans, Zelda Perkins and Jonathan Taylor. It's a shame that it takes immense bravery to speak the truth. And this takes us to the government's whistleblowing framework review, which provides the government an opportunity to tackle wrongdoing across all sectors and to consider what the forms may look like. It is a great privilege for me to introduce our panel. And I hope they're sitting almost, that's not too bad. So having sat at the back this morning, I would say that that's pretty much it, except when you hear a female voice, that's Liz. And she's sitting next to me. Ian Foxley became a whistleblower in December 2010 after discovering corruption in a $2 million government defence procurement contract. $2 billion. $2 billion, thank you very much. Whilst working as the Programme Director in GPT Special Project Management Limited. His actions resulted in criminal prosecutions, the complete overhaul of the Airbus Group senior management team, and the largest fine under a deferred prosecution agreement ever imposed on a company in the world, $3.6 billion. Jeremy Lewis, King's Counsel, is a leading practitioner in employment litigation with particular areas of expertise in TUPE, whistleblowing, business protection, injunctive relief and discrimination. He was appointed King's Counsel in 2022 and is a mediator and fee-paid employment judge. He is co-author of Whistleblowing, Law and Practice, now in its 4th edition, and has appeared successfully in various significant whistleblowing cases, including Ibrahim and HCA in the Court of Appeal on the public interest test. Sean Parker specialises in safety reporting. Sean has over 25 years regulatory experience with the CAA across several technical disciplines. He initiated the CAA whistleblowing processes in 2008 and continues to lead this activity. As the head of the CAA's Safety Data Department between 2010 and 2014, he was directly involved with the drafting of the Occurrence Reporting Regulation as the UK specialist supporting the Council of the European Union. Elizabeth Gardiner was appointed as Protect's Chief Executive in March 2020. She took over as Acting Chief Executive just before the first UK lockdown and successfully steered the charity through the troubling years of COVID. A qualified solicitor, she also has extensive experience in Parliament and policy work. Elizabeth is a member of the Whistleblowing International Network Board of Trustees. My first question then for each member of the panel is, does the Public Interest Disclosure Act provide adequate legal protection for whistleblowers to enable the early raising of concerns to stop scandals and disasters happening Perhaps if I could start with you, Liz, please.
Well, we're the first at Protect to recommend that we need to reform the law to bring it up to date. But has the law worked? I think we should reflect on that, and I think it's worked in two ways. First of all, it has helped whistleblowers, and secondly, it set the framework for whistleblowing. Now, on the first point, we heard from this morning just what whistleblowing was like 30 years ago. And if the law recognises that you should not be victimised as a whistleblower, then that does shape the public awareness and understanding of whistleblowing. And for some whistleblowers, the deterrent effect that the Minister was talking about just now means that we do have better workplaces where employers take whistleblowers seriously. And for other whistleblowers, the law has worked to provide them compensation when things have gone horribly wrong. The tribunal system, we do occasionally see very large payouts for whistleblowers because the injuries to them can be lifelong in terms of the impact of their whistleblowing. Just last month we saw a £150,000 award given to a nurse in Wales who had suffered as a result of whistleblowing. So some whistleblowers have benefited from the law. But I also think the framework that it sets is really important, because the way our current law works is it encourages people to raise concerns early with their employers, giving their employer the best chance to address that concern before it becomes a really big risk. And there's a really careful balance that the law creates between encouraging but not requiring you to go to your employer. So in cases where it is your employer doesn't listen or it's too difficult to go to your employer, then the law builds in the regulators and indeed the media that we've heard are so important in stopping harm as well. So there are some final checks and balances that the law creates. So to some extent it's worked, but we heard this morning that the current law is very much an after-the-event remedy. And when we're talking about whistleblowing, as so many people said this morning, it's about holding people to account. And we've put all the emphasis on the remedy for the individual and nothing in the law about the accountability of the institutions. And that's really what we think is a really serious gap that's now emerged. As the Minister also said, it doesn't reflect today's workforce. 30 years ago, we could not have imagined how many people are working in the so-called gig economy. Self-employed contractors are a commonplace in our workplace, and a number of people are not covered by employment protections where they should be. Employers who don't have those serious regulators that we've talked of this morning can and do ignore whistleblowers and take their chance as to whether they'll bring any claim at tribunal. And 25 years down the line, we've had loads and loads of case law. And that actually has made things very complex for the individual who wants to navigate through a tribunal process. It's an enormously difficult piece of law and very, very difficult to navigate unless you've got a specialist lawyer on hand. So reform is necessary, but that's my take on where we are today.
Thank you. Quite interesting. I think many people will be surprised that for many employers you can lawfully ignore a whistleblower. Ian, same question to you, please.
It works, but it doesn't work well enough. There are too many people that it doesn't cover. If it's focused on employment law, what about all the whistleblowers who are outside of employment law? What about the Me Too world? What about the child abuse world? All those people who actually raise serious issues and who then suffer detriment from a number of different areas are not covered by PIDA. So we really need to widen the scope of those who are covered. From the point of view of a whistleblower and one who has been to an employment tribunal and it was dismissed because it was out of jurisdiction, there are holes, and those holes need looking at and addressing and rectifying. I had a phone call last night. It was an hour and a half from a lady in a very difficult situation who went through an employment tribunal that was again thrown out on jurisdiction. And that's against a major corporation in this country who proclaims itself now as having learnt the lessons of how to protect whistleblowers. So the holes are still there. It's happening on a daily basis, and we need to do something about it now. And I hope the review will actually show that and put forward recommendations which are worthwhile.
In terms of jurisdiction, perhaps you could clarify what you mean by that. What types of arguments are run that prevent whistleblowers from having advantage of the jurisdiction of the Employment Tribunal.
Okay, we're now particularly in the world of fraud and corruption. We're in the corporate world where an employee is working for a subsidiary of a large corporation, which may well be UK-based. In fact, the subsidiary might be UK-based, registered at Companies House. But the employment contract is framed to be subject to the laws of another country in which they're working at the time. When you take that to an employment tribunal, unless you can show the balance of your time in employment was more in the UK than in the foreign country, you are outside the jurisdiction of the Employment Tribunal. Now, I know that the Anti-Bribery Act 2010 was meant to address this and make fraud and corruption a global crime, but it doesn't seem to have been extended into the world of the Employment Tribunal. And I can give you, I've got 3 or 4 examples of my own, plus others who have come to me and we've helped en route, where they've all fallen foul of the jurisdiction rule.
Thank you. Sean?
I think I'm the token regulator. We had the token man earlier, didn't we? I'm the token regulator, so my ears have been burning this morning. I found myself in violent agreement with a lot of things that have been said this morning, though. I think to answer about PIDA, it's probably worth me speaking about the regulations in the aviation industry. So, bearing in mind, I sort of run our whistleblowing and that area. PIDA legislation is largely irrelevant to me, which seems a bit bizarre. That's because we have regulations in the aviation sector which go a lot further than PIDA do. So it's almost become an irrelevance because we cover it within our own regulations within aviation. So back in 1976, so 15 years before this charity existed, we had legislation in the UK to do with occurrence reporting was described as. So that the basis of that was that it was recognised employees in the aviation sector, if they speak up when they see there's a problem, their employers could learn from that and stop aircraft crashing, basically. And that legislation has been amended numerous times over the years, and we've learnt along the way. And where we are currently, the legislation, I think a key point here is it's not just about protection for whistleblowers or for people speaking up. It's also about putting requirements on the organisations themselves, the employers. So in my world, the employees are expected to report things. In fact, it's a requirement that if you're a pilot, an engineer, a air traffic controller, there are certain things you legally should report. Now, to do that, your employer has to enable that through an internal reporting process and system. So every aviation company has to have a working internal process for this type of thing. And that process isn't just about receiving that information, it's about using that information to improve. So an employee reports something, the organisation analyses that, they investigate where necessary, they get to the root cause, they make changes, and they give feedback to the whistleblower. A key thing, the feedback then gives the we don't use the word whistleblower very much, but well, for this context, gives the reporter, if you like, the whistleblower, the reassurance they have been listened to and that either they were wrong and mistaken, in which case they now understand there wasn't a problem, or if there was a problem, what has the company done about it? What have we changed the procedure, bought some new equipment, whatever. So that idea that it is commonplace, it is normal for employees to speak up when there's a problem, the company listens and does something about it, that's just the way it is. So it's no longer, oh gosh, it's a whistleblower, that's unusual. It's a day-to-day thing. Everybody speaks up every now and then when it could be they're aware of a problem, or it could be that they've messed up themselves. They've made the mistake. But the culture is such that even if you've made the mistake yourself, as long as you report it appropriately, it's recognised that we all make mistakes. So we look at not who's to blame for that error, but why did you make the mistake? What were the circumstances on that day? What were the contributory factors that meant it went wrong? Because, aviation employees are professional people. They don't go to work intending to make mistakes. So if it's gone wrong, it's probably because there was something wrong in the environment around them that made it go wrong. So don't blame the person. Let's look for the problems with the system.
And Sean, just so we're clear, because most of us will be shocked to hear how brilliant this system is, you're not just talking about the black and white of policy and procedure. You're talking about what actually happens.
Absolutely.
To what the culture is.
So the starting point is regulation. So it is UK law, it's European law. It was mentioned in my intro, I was involved with the European law, which since we've left the EU, it's the equivalent is now in UK law. So that's the starting point. But then on a day-to-day basis, when my colleagues go and do audits of all the different companies we approve within aviation, part of the process we go through is looking that this happens. So part of our audit schedule is looking to see they have a functioning internal reporting process. What sort of reports do they get? How do they handle them? And not only that, these reports get forwarded to us. So we have I set up this whistleblowing process in 2008. So 1976, we had this occurrence reporting process. 2008, because of all this stuff, we set up a whistleblowing process as well. We get about 300 whistleblowing reports a year, which for the size of our sector is quite low. We get 60,000 occurrence reports come to us. So the whistleblowing part is tiny compared to the normal behaviour. So the fact we receive an occurrence report is not a surprise. That's what's supposed to happen. So the industry learn from that, but they also tell the regulator, so we can spot trends and maybe we have to change a regulation or focus on a particular area. So everybody benefits. It seems like a no-brainer, but it seems to be a challenge in some places.
Well, we know just culture has been attempted in the NHS and elsewhere, and it's not been as successful, to put it mildly. Jeremy, finally to you.
Thank you. It seems to me that when you're looking at whether there's an effective system or not, you need to look at a number of different aspects to that. And that's partly reflected in what's been already discussed this afternoon. So one element is the scope of legal protection, who's covered, what's covered, and what remedies there are. But also, it's looking at how effective that is in practice when you get into a tribunal or on the way to a tribunal. And it's also reflected in what other obligations there are in place beyond the legal protection against victimising for whistleblowing, and the interaction between that and the role the regulator plays in providing the right sort of environment. So if you take the first of those aspects, the scope of legal protection, it's not difficult to pick holes, but I also agree with Liz that one shouldn't lose sight of the benefit the legislation achieves, and I see this in my work day in, day out, whichever stage I'm involved in or advising, and the employers become aware of what their obligations are. The nature of the rights become important when one's discussing where to go with the claim, whether it be for the worker or for the employee, and lots of cases may seem to be dismissed, but a lot of them are dismissed on withdrawal because the settlement's achieved. So one shouldn't lose sight of the benefits, but there are areas that can be improved. And also, one shouldn't lose sight of the nature and the scope of the issue that this legislation seeks to deal with. So, for example, if you draw the contrast with the directive, the European directive, that's dealing with, in the first instance, disclosures that are made either to a regulator or effectively under a whistleblowing procedure before going more widely. The legislation in this country is dealing with whistleblowing that can come in all different shapes and sizes, and has to deal with the different challenges that leads to. So it may not be a formal blowing the whistle to under a whistleblowing procedure. It may be raising concerns informally. It may not be expressly setting out the allegation because there may be a concern about not being seen to be alarmist, but nevertheless the allegation, the relevant facts are raised. It may be sometimes raised as a matter of urgency. It may be raised to various different people. And on the other side, there are sometimes cases where allegations are made, perhaps against colleagues, which aren't substantiated, and one has to deal with the dynamics in the workplace. And this legislation has to deal with all those different scenarios. And I'd suggest that, broadly, the structure that's set down isn't bad. It can certainly be improved in areas, and there are proposals that are made, we can come to that. And equally the remedies, it goes quite a long way compared to many employment rights, day one rights, unlimited compensation, no cap on compensation, claims potentially against individuals and agents. But there are areas there that can be improved, such as the interim remedies for detriment. So I'd suggest one shouldn't lose sight of what there is, albeit recognising there are gaps in terms of who's covered and areas that can be improved. But that has to be looked alongside the second element, the effectiveness in practice. Because whistleblowing cases are often complex. The individual whistleblower often can't afford a lawyer, whereas the employer more often can. There are factual issues that have to be determined, whether it be the question of whether the detriment was influenced by the whistleblowing, or what was said if there was a verbal disclosure. And when you get into those sorts of factual disputes, it does make a difference if one side has a lawyer, or often makes a difference if one side has a lawyer and one side doesn't. And that's a practical problem which makes the issue difficult and scary if you're going to a tribunal. And there are other things that can come into the mix in terms of, even in the tribunal, cost threats. So one has to look very carefully at what can be done with the system, and there are things that can be done, and we can come on to that later. And the other third element is, what obligations are there beyond the obligation not to victimise? And I agree that there is more that can be done in relation to that. Compares the European directive, for example, where there is an obligation, albeit with a more restricted set of whistleblowing that can be covered, but an obligation, positive obligations on the employer, not only not to victimise, but also to risk assess, to put steps in place to protect somebody who has blown the whistle, maybe to monitor the situation and certainly to ensure confidentiality. And that can be important, because one of the biggest difficulties in many cases is to establish the reason for treatment. If you've got a claim based not just of having to show you've been treated badly because you blew the whistle, but you've suffered bad treatment because positive steps haven't been taken to protect you, that gets over the need to show that a failure to act was deliberate, and it gets over the need to show that the failure to act was because of the whistleblowing. So that's an important step that can be taken. The other thing that can be put in place are steps to, and where there's a gap, relates to obligations to investigate, to assess, possibly to feed back that we have in Europe. And again, it might be said, well, is that something to go to a tribunal? We don't have that going to a tribunal. And there may be other places to go to as well, but a whistleblower who doesn't have matters being taken further, can't see the evidence of matters being taken further, may be led into escalating matters, may have the stress of being in the invidious position, what do I do when it's not being addressed, may ultimately decide to resign. So again, it's another area where the protection needs to go beyond just protecting against detriment, but also protecting against the consequences of the situation a whistleblower is put in where matters aren't adequately addressed. Now, there's a debate to have as to whether that applies to all whistleblowing or a narrower element where, for example, it's a formal grievance or it's formally raised in a whistleblowing process or some other way that it's raised to the employer. And that goes alongside what else may be put in place by the regulator. So let's not lose the sight of the benefit of what we have, but in all those three aspects, if one looks at all elements of it, one could certainly have a more effective system.
Thank you, Jeremy. So I think we're unanimous in that whilst PIDA has benefits, there is more that can be done, and Jeremy has started the discussion about what reforms could look like. But I'm going to ask each of our panellists that if you had the power, what would the reforms look like? Sean, perhaps I'll start with you.
So, it's been mentioned a couple of times this morning, the importance of culture in the organisations, and I think for me the thing that's missing currently is the expectation that every employer, every organisation has a functioning, effective internal reporting process that people can trust. So if any changes included the requirement for organisations to have that, And it's not just a process of receiving reports from employees, it's about what you then do with those and providing feedback, etc. If that became the norm, that would drive the culture of it's normal to speak up when something's wrong, and hopefully you wouldn't end up with it in the tribunal, because it's just commonplace. That's what we do here. We speak up, the company listens, we learn benefit from that, and we all move on. So the biggest single thing for me is getting employers to have that internal process.
So our relationship with wrongdoing should be such that we all think it's bad and we all feel comfortable in raising concerns.
Yeah, I mean, things go wrong. That's a fact of life. And so if we just with aviation for a second, if we go back to the sort of 70s, we had aviation accidents where we learnt from those and we moved on. And in that sort of era, it was very much a question of who's to blame. We moved to a point where it's not about who's to blame, it's about why did it go wrong. If you start an investigation looking for whose fault is it, you stop quite quickly usually, and you don't benefit the organisation. What we need to do is say, well, why did that person get it wrong? Because very often the person who's got it wrong is one of your best employees. They were trying to do the right thing and it went wrong. Well, why did it go wrong? The investigation should focus on those causal factors, because if you can get rid of those, it won't go wrong again another day. If you blame someone and sack them, but all those contributory factors are still there, it could go wrong for someone else in a month's time. So having that mindset that let's learn from these mistakes so we can stop it happening again is all fundamental to what whistleblowing is about.
Yeah. Ian?
I think the CAA are unusual. They're unusual. You are unusual because as a regulator, you have an environment where the whole climate of reception of a declaration of wrongdoing or something that's gone wrong is accepted positively. And there's no great blame culture. There's a kind of amnesty that occurs where the disclosure is investigated and then remedies are put in place, and blame, if blame is correct, is apportioned correctly. And the person raising that disclosure is not the victim. They're not actually held to account for raising it. What's held to account is the fact that something's gone wrong. A bolt has gotten an engine and an aircraft crashed. Why did the bolt get there? That's what's traced out. But I think you're unusual. I don't think we find the same in the FCA. I don't think we find the same in the NHS. We certainly don't find the same in the Catholic Church. Hands up all Catholics. So that's what needs to change, is the culture of reception of the disclosure of wrongdoing. And if there's one thing that I'd love to see, it would be that the onus is on the organisation who respond to respond positively. And how you bring that about, it's cultural change, and that will take ages to do. But we've all got to go down that path. I've just completed a PhD in thank you very much, graduated in July. I'm now Dr. Fox. But I researched why people do not speak up. And I was very lucky. I used my own case where I was the whistleblower, and I interviewed everyone around me and above them and above them and above them, up to a man who was the advisor to the Prime Minister, as to why they knew about it, if they did or didn't, and why they did or didn't speak up. And the root causes are fivefold. Firstly, it's fear. Fear of your job, your loss of income, your mental health, your domestic peace. And that is the big reason. And that comes down to lack of protection of the whistleblower. And that's the core of the problem. The second problem, I come back to this thing about inequality of arms. It is the individual looking out at what happens to other people and says, if I blow the whistle, I'm an individual, they are a massive organisation, they have all the power, they have the money, they have the expertise, they have the access to the KCs. I don't. How do I fight them? And it's like treading in a minefield. You're going to get your legs blown off, but you're not going to get to the other side. And so they don't. So it's futility. The third reason is that they're complicit, or the organisation persuades them that they are complicit. It's the boiling frog syndrome. You know, I put you in the water and I warm you gently till it's too late. And then I tell you that if you blow the whistle, you're complicit and you're going to get prosecuted as well. So they don't. The fourth reason is actually guerrilla government. They're not brave enough to blow the whistle, but they actually find another way of leaking the information. This is classic in the civil service. Yep. They don't want to lose their job and their career, but they hate what's going on. And so they assuage their own self-esteem by doing something for good. I leak it. The last one is the political excuse. This is the one that our politicians want us to believe. We do it for the greater good. I get my hands dirty because I have to. I don't like it, but I have to. For the politics, for the strategy, for the economy, for my allies, my strategic allies. And therefore I do it on your behalf. But it's dirty. It's absolutely dirty. And if leadership, the national leadership, is not clean, then those below them will not be clean. We have a programme of offering support and advice to Ukraine, which we've been running for 6 months. And I spoke with the head of the anti-corruption agency in Ukraine, Singh, and I said to him at the end of a long discussion, there's only one thing that you've got to do, Singh. You've got to go and see President Zelensky, and you've got to tell him that if he doesn't start cleaning up corruption, which is endemic across your country, you will not be seen to be rebuilding a clean country, and your funders and your support will walk away. And Singh went to see Zelensky, and 2 weeks later, they arrested a minister. 2 weeks after that, they arrested the chief judge of the Supreme Court. And 3 months after that, they declared corruption across all the regions of those governed with ensuring that, you know, youngsters could actually go or not go into the army, because it was rife with bribery and corruption.
That's a great example there, Ian. Thank you. I'm going to ask, I've got 2 lawyers to speak on law reform. I'm going to ask if they can pick their top 3, if you like, just because I'm just mindful of time. Particularly perhaps addressing some of the 5 points Ian has mentioned. So what would reform look like? Maybe just pick out your top 3. Do you want me to go? Liz, you go.
Yeah. OK, so as you know, we've got a draft bill, which Tom was very complimentary about this morning, because it is absolutely everything we want to see changed in whistleblowing. But we do have three key asks. One is that very simple one that a lot of people have spoken about already. Let's widen the scope so that everybody who's in the workplace who might see wrongdoing and might suffer as a result of raising that concerns is covered by the protection. So let's have a broad scope, really simple, doesn't need primary legislation. Let's just get on and do that. The second one is access to justice. We've got to make life easier for whistleblowers who do face the tribunal, so that imbalance that Ian spoke about. We need to change the tests. We need to make it, the time scales easier. We need to make sure we reverse the burden of proof, change the tests, that all those hurdles that a whistleblower has to jump to get to justice. And the third one, I think, really builds on what both Jeremy and Sean have been saying about accountability. If we really want to change this conversation, we need to start seeing more responsibility on the employer. Because 25 years we've had of saying, well, here's the deterrent effect. All you employers, it's a really good deterrent. If you don't get it right, you'll be in front of the tribunal. Well, it works only up to a point. So if we've got great swathes of the country that are not covered by any kind of whistleblowing arrangements, and we absolutely found that during COVID, we had thousands of people calling us saying, I want to report fraud, quite a lot of fraud going on during the COVID, and there is nowhere I can go internally at all. So, of course, they go straight to their regulator, and that's worse for the employer, it's worse for the individual, it's worse all round. So we want to see responsibilities placed on employers, and we want to see some minimum standards. As Jeremy said, in the EU directive, it's already there. Why can't we have that here? Let's have something like that here. But also, if you start putting standards on employers, you don't have to leave the whole fight up to the individual to enforce those standards. We could have another body, just as the Equality and Human Rights Commission enforces equality standards without having to have somebody bring in a claim. You could have a body that then can enforce standards on employers and shift that balance so that we talk about accountability of organisations and not victimisation of individuals.
Yes.
Well, I'll try and avoid duplication because I agree with what's been said, and I think it's also very interesting to hear your analysis, Ian, of the 5 elements. And I think we all need to go away and think about how that feeds through into policy. I'm just going to, and I'm not going to repeat what I said earlier about the positive steps, because I fully agree with Liz. That would be right up there in my top 3 otherwise. I think it was interesting when we heard from the Minister, Kevin Hollandrake. He said that it's a good thing to have employment tribunals of places where nobody wants to go. And I'm not sure I can fully. Clearly, nobody likes being in the tribunal, but as a model of trying to enforce legislation, to have that nobody wants to be there is not necessarily ideal. There is a key issue as to access to justice, and there are some practical things that can be done. And one can look at borrowing from other areas without. If we take it that we're not going to get more funding for things like legal aid, you can think of ways around that have been adopted in other areas. So one possibility, if you think about the model which is used in personal injury, is that there's a system of qualified one-way cost shifting, so that the way that those who bring claims can often get lawyers is that lawyers will be prepared to act on a contingency fee because there are costs that are awarded. So one thing that might be worth thinking about in the tribunal is to change the rule so that if a whistleblower succeeds, not if the whistleblower fails, but if the whistleblower succeeds, that costs would follow the event. That would make it easier for the individual whistleblower to get a lawyer. There can be other things that can be changed in the cost rules so that to make it more difficult to make a threat of costs in the personal injury field. The personal injury isn't my field, but I had touched upon it in certain areas. One of the things that is done is to restrict the areas in which there can be adverse costs, either by limiting it to what's from any award, or by limiting it to where the claim is fundamentally dishonest. So one could restrict the areas in which there can be costs awards to restrict the area to have that threat against the whistleblower, but also increase the likelihood of the whistleblower being able to get legal support. There are other things that can be done with the system. It needs to be speeded up and so forth. But there's just a couple of ideas that we can think about, and maybe others, in relation to access to justice. The second element, if I'm picking a different area from other people, is in relation to what can be done to stop things earlier in their tracks. So one of the developments, but in a very narrow field for applicants in the NHS, is that in that case discriminating because somebody's appeared to make a protect disclosure, that's treated as being a breach of a statutory duty, with the effect that you could seek an injunction in the ordinary courts to stop a detriment pending the matters being sorted out in the tribunal. That might be, for example, used to deal with a suspension. It might be something which is effective in conjunction with the sorts of positive duties that we were talking about earlier, to stop matters earlier on in the process, and as well as a deterrent. To be effective, it may need to be allied to some sort of change of the cost system for these sorts of claims in the ordinary courts as well. But it provides a mechanism, potentially provides a mechanism, for dealing with matters before they've got to the stage of the worker being dismissed, to get things back on track, albeit with the limits that might apply with the courts not wanting to get over-involved in micromanaging. So it's another area that can be, the scope can be widened. And then I agree that there are aspects that can be dealt with in terms of the nitty-gritty of the current provisions. So, for example, just to pick out a couple, in different areas, the test of reasonable belief, that in the way it's applied in the case law should be more flexible. It should be able to deal with situations such as when you've heard evidence second-hand or first-hand. But the law would be clearer and better if it applied to reasonable concern, reasonable suspicion, where somebody wants to raise a matter and it isn't necessarily confident about what's gone wrong, but believes it's the right thing to raise it. And equally, when it's about something in future, there shouldn't be a test of is it more likely than not to happen. It should be a test of this may well happen. That should be enough to be able to raise a matter. So there are issues that can be dealt with in all the elements I identified before: access to justice, and practical effectiveness of the legislation, positive obligations, and the content of the legal protection itself.
Thank you, Chairman. I'm glad you raised costs as well, because there's been some high-profile whistleblowers who've faced adverse cost threats and orders recently, and that in itself has a chilling effect. We have 6 minutes for questions and answers. This gentleman here, and there's a lady at the back. Thank you.
Yeah. Hello. Yes, Liz, you mentioned you said all the emphasis is on the remedy at present. I'd like to suggest that that all is not well with the remedy situation, because you know as well as better than I do, the remedies, there's reinstatement, there's re-engagement, there's compensation. We've heard a number of references to compensation. Well, in my experience, from what I know, compensation is typically pretty paltry and nowhere near true compensation for the effects of loss of career, and it doesn't. Anecdotally, it doesn't usually even cover legal costs. Has there ever been any instances where whistleblowers who have found to have raised concerns, protected disclosures, been reinstated? Because in my experience, when I told the judge that, the judge said, what remedy do you want? And I said that. She said, oh no, that can't happen because of a deterioration in relationships with managers. Well, actually with some managers. How on earth can you go through an employment tribunal that you've been funneled into in the absence of anything else without there being some sort of, without there being a deterioration in relationships with the individuals who've unfairly dismissed you?
Should we just answer that one there? I think you're absolutely right, but the fact that you've got to a tribunal is almost taken as read that the relationship is irretrievably broken down, and that's a shame because, you know, as Jeremy said, you know, that maybe there should be a remedy that allows you to re-engage, and I think there is some emphasis now on a bit more mediation, a bit more alternative dispute resolution, and perhaps we don't consider that often enough and soon enough in the whistleblowing journey. And I do think that, you know, one of the things that we often do when people come to us on the advice line is we try and help them frame their whistleblowing in a way that doesn't develop into that conflict between employee and employer, because, as we've heard lots of times, mostly the employee is working in the employer's interests, they share the values, they want the harm to stop, and we should be able to retrieve more relationships. So, you know, I'm sorry that, you know, your situation ended as it did, but I think you're right. We should be looking more at how do we get remedies that don't end up in irretrievable breakdown as a matter of course.
I think also, when we say irretrievable breakdown, well, we say that sometimes, then we go to mediation and we resolve issues on mediation, and we look across the world at conflict and how mediation has worked. I think it's a bit defeatist to say the relationship is broken down, there can't be reinstatement.
Well, I'm all for alternative dispute resolution and mediation, but in my experience it doesn't work. And I think you've just confirmed, Liz, that reinstatement and re-engagement, in practice, they don't exist either in terms of protecting somebody's career.
Yeah. Well, I think once you've got to tribunal, you're probably right. Yeah.
There's a lady at the back first and a lady at the front. Thank you.
Kat was hoping for a list of the people that have come so far today.
Thank you very much. My name's Monique Buffet. I'm a junior barrister out of Temple, so I've got quite a big claimant whistleblowing practice. One gap that I'm interested in, and I'm really interested in the panel's views on, is the difficulty with whistleblowing and its interaction with other forms of discrimination. Because what I frequently see is when you have a whistleblower who also has a protected characteristic, so it might be a woman or a person of colour, they're often treated badly, not just because they're blowing the whistle, but because they're the brown woman making a fuss, or their protected characteristics is very much involved in how they're treated. And the problem is, obviously, that claimants are having to then squeeze their claims either into whistleblowing law or discrimination law. And sometimes I think a good judge might see the nuance between them. But in reality, this isn't like a dual characteristics case. You've got judges who are having to grapple with two very, very different pieces of legislation. So, yeah, I just wanted the panel's views on whether there is a gap and how that could be reformed.
So, kind of intersectionality, but with the status of the whistleblower. I know, as you know, Liz, when I first came to PCAW, one of the first things I raised was my concerns whether we've looked at, for example, is a woman more likely to be listened to than a man, or is a man more is a person of colour more likely to suffer detriment as a whistleblower? What work is being done in this?
There is some research in that area, and I think it's a really hard. I think you're absolutely spot on. You know, why should a person who's been treated badly for both those reasons have to then, you know, have that negotiation about which one of these laws is going to be more likely to help me? Because the research that has been done at the University of Greenwich looked at, you know, actually when you bring both cases, you're less likely to have success all round, and I think there's a little bit of evidence, as I said earlier today, that about women. I don't think there's any evidence that I've seen about what happens with people of colour. So that's a piece of work that we do definitely need some more research on, and we should never be in that situation of trying to, and we have it a lot on the advice line, you know, trying to advise people, well, you've got both these claims, which one of these is going to be easier for you to get over the line with it when it comes to tribunal? I mean, it's a terrible situation that we're in. Jeremy might have a bit more experience.
I'd say two things. First of all, I think there is a danger sometimes of a judge thinking, is this a scattergun claim? If you're alleging a number of different things, does that invalidate each one? And that shouldn't really be the case, because it's in the nature of both types of claims that it's for the employer to explain their reasons for acting. And you're often not going to have direct evidence of that. It's a matter of inference, and it ought to be possible to say it's for them to explain. There can be inferences of both these things or a combination of them. And I think generally the judges will get to that point, but there may be an immediate scepticism, but there shouldn't be. And in most cases, there probably isn't. Secondly, there is unnecessary complication in the law. There are differences between relevant tests, I think was alluded to before, that apply for discrimination and that apply for whistleblowing. And there's no reason for that to be the case. There's no reason why the test for an extension of time for discrimination should be different to the extension of time for whistleblowing. There's a good argument the time limit for bringing a claim is too short for both of them, but in any event there shouldn't be a difference. There's no reason really to have a difference in the burden of proof between the two, and those sorts of complications are barriers to justice, and the sooner they're resolved, the better.
I do apologise. You have had your hand up. Perhaps we could just have that one last question. Yes, tiny question.
Thanks very much. We had input from two politicians, but no one said anything about that. And I wondered if the panel would be willing to comment a little bit on what they see the opportunities as in the current government, given the limited time left. What are the real opportunities? And or if Labour's committing to legislation in its first 100 days, does that look promising?
Shall I just quickly take that? I think we're at that point that Guy talked about. You know, there's a wind of change, and I'm really hopeful, actually, that either this government or the next one is going to grapple with this, because there is under so much pressure from a number of different organisations and from businesses as well, who are saying, you know, actually we're not there yet. We haven't got this right. We do need to reprove this. So I think we've got. I'm really hopeful. I'm optimistic there will be change, and I think, you know, both of those politicians gave us a glimmer of hope. A glimmer of hope.
It's always nice to end on an optimistic note, and I thank the panel and yourselves, ladies and gentlemen, for your time. Sorry for running.